Hi, my name is Andrew Polis, and I'm a professor at Case Western Reserve University School of Law. I'm also an attorney in the Equality Ohio Attorney Referral Network, and I'd like to share with you a couple of thoughts today about how you can protect your rights as a tenant when something goes wrong in your apartment. First, anytime anything goes wrong, you always want to notify your landlord. Everybody knows that, but you want to make sure you do it in writing. An email is fine, but you want to do it in writing because if you don't do it in writing, then you haven't set yourself up for some remedies that the law provides for you, and you also subject yourself to a dispute about whether you said anything, because whatever you said, the landlord is going to obviously have another version of the story. The second thing is that you want to always take photographs of anything going wrong in your apartment so that you have them as evidence if you need to bring the case to court. Which takes me to point two. Point two is that when you have a problem that goes wrong in your dwelling, you obviously want to be relieved of some rent obligation if the landlord refuses to fix it timely. But a lot of people mistakenly think that means that you can withhold rent from the landlord. And while you sort of can, you can't do it just by not paying it. What you have to do is pay it into court. When you do a rent deposit, which is what it's called, into court, the court will take your rent, and they'll take a little bit more for what they call poundage, so it will cost you a little bit more. But you can deposit your rent into court every month or every week or however your rental obligations are normally due, and your landlord will not get any of that money unless and until the problem that you've complained about is addressed. Now, that may not mean fixed, because the court could find it's not a problem in the first place, but if it is a problem that needs to be fixed, the landlord has to fix it before any of that money will be returned. Last, security deposits. Lots of us assume that when we leave, the landlord will send us our security deposit, but of course that can't happen unless the landlord knows where to send it, which is why Ohio law requires that the landlord's duty to return a security deposit isn't triggered until you provide a forwarding address of where you want that security deposit returned to. The landlord can deduct things from it, can deduct unpaid rent or other items of damage that you caused to the dwelling, which is another reason why you want those photographs to make sure that you've documented the state of the dwelling on the day you leave before you turn in the keys, just in case there's any dispute about that. Now, if the landlord does not return the security deposit to you within 30 days of receiving that forwarding address, or doesn't send you an itemized list of all of the bases the landlord has for deducting things from the security deposit, in whole or in part, if the landlord doesn't do those things, then you are entitled to recover not only the security deposit that was taken, but also twice that amount, or not also, a total of twice that amount. So for example, if you paid a $500 security deposit, you might be entitled to $1,000 if the landlord doesn't do what the landlord is supposed to. And you can even hire an attorney, and the landlord will have to pay the attorney's fees if you are successful in suing the landlord for the unreturned security deposit. So those are my tips for you. I hope those help you in your tenant experiences, and you're always welcome to reach out to me if you have any questions.